Very good evening and welcome to the webinar on Roadmap to Become an AOR. This webinar is conducted by LegalAdobe with collaboration with Law Shastra. LegalAdobe is a platform founded by Advocate Shilpi Yadav under the chief mentorship of Advocate Rohit Pandey. Unfortunately, we do not have Mr. Rohit Pandey with us today because of his prior appointments. This is our team, and we conduct webinars, workshops, and also provide internship opportunities to law students. You can visit our website for all kinds of legal articles as well as judgments. And you can also visit our social media pages. Before we start, I would like to give everyone a couple of instructions. Kindly keep your cameras and mics off for the entire duration of this webinar to avoid any distraction. Please do not write your name or qualification in the chat box, and please provide your valuable feedback after the session. Now I would like to introduce our speakers for the evening, Ms. Archana Pathak Dave and Mr. Namit Saxena. Our first speaker for the day would be Ms. Archana Pathak Dave. Ms. Archana Pathak Dave is an advocate on record at the Supreme Court of India and is practicing law for more than 18 years. Ms. Dave represents the state of Gujarat before the Honorable Supreme Court of India and is also a Panel A counsel for the Government of India. She has represented many public sector undertakings before the Apex Court. She has been a part of many path-breaking judgments, including the much-awaited Permanent Commission to Women in Indian Army, the famous privacy verdict, and the landmark judgment of Ram Janmabhoomi title case, the longest pending and most contested litigation of Indian history. Ms. Dave was also involved in the Constitution bench judgment, which held that the asking of votes in the name of religion is against the Constitution of India. She has been appointed as an amicus curiae in Prakash Singh versus Union of India, which is the issue relating to appointment of DGP in states. Another important matter of a great public importance is medical negligence, where she's assisting as a senior advocate and co-amicus curiae. She is also an independent member of the Prevention of Sexual Harassment at Workplace Committee of Ramjas College, Delhi. We are honored to have you amongst us today, ma'am. I would now request you to take over the platform.
Hello, good evening, everyone. I think Namit ji has also joined. So, sorry, Namit ji.
Ma'am, you're not audible.
Oh, well, am I audible now?
No, ma'am, we still cannot hear you. Your video is visible, but you're not audible.
Is it fine now? Can you hear me? Can you hear me now? Can you hear me now?
Yes, ma'am, you're audible now, yes.
Okay, thank you. I was just saying that I could see Namit ji has also joined now. And Namit ji, I took this opportunity to start the webinar since you joined a bit late. So I was thinking instead of, everyone waiting if I can start. So if that's all right with you, I can start with, the subject, the topic for today. Roadmap of becoming an AOR. That's the topic for today's discussion. And if you really want to practice in Supreme Court, then becoming an AOR is a sine qua non, according to me. Of course, if you're not an AOR, you can still practice. You can be an arguing counsel, but if you are an AOR, there are so many things that you have an edge in matters, the registry recognizes you, and there are things that it's possible only for the AORs to take care of. And of course, being an AOR doesn't mean that you cannot argue. So you can do both. You can argue as well as you can file your cases. And at times, when you have to, when there are certain urgent matters and you want to do things quickly on your own, then it is very important. So I will tell you a few guidelines. I became an AOR. I gave the exam in 2013, and I passed it in the first attempt. Maybe because of the fact that I was practicing regularly since 2003, and almost on a daily basis from 2008. So it was easy for me because I was practicing, and I had to read less of the papers that time, because most of the syllabus that is there in the AOR exam is based on your day-to-day knowledge that you gather in the Supreme Court. So there are 4 papers. I don't know, most of you must be knowing about the number of papers and how to attempt them, but I'll just briefly discuss with you so that I can then take my talk forward. So there are 4 papers in the AOR exam: practice and procedure, drafting, leading judgments, and professional ethics. And you have to pass in each one of them. And the maximum chances that are given are 5 attempts. I mean, to my mind, 5 attempts are like more than enough. But okay, so practice and procedure, that's the first paper. And this paper is totally on your practical day-to-day knowledge, which you gather when you are there in the Supreme Court, taking care of your matters, sometimes on behalf of your senior, or when you are taking training under an AOR. So let me tell you that to appear in an AOR examination, you need to be enrolled for 4 years, and thereafter 1 year of training under an AOR is important. After you complete these 5 years, 4+1, then you're eligible to appear in the AOR examination. So practice and procedure is something which I loved the most, because there was nothing to cram actually in the paper. Whatever I was doing on a daily basis was what was required and was asked in the exam. I just also had a look at this year's question paper of the AOR exam, and I was surprised to see there were things like, is there a mediation center in the Supreme Court, and how does one approach the mediation center? So these are things that we are doing practically when we are taking care of our cases. So it is important that you are actually practicing, you are there in the Supreme Court, and doing what is an AOR required to do, because when you're taking a training under the AOR, then he or she would be telling you different things to do, and these are certain things that you probably you won't find in the books written, but just doing it on your own will help you. Second is drafting, and it is a very, very important paper, because drafting involves so many skills. One is that you have to be really, really quick. You have to attempt questions, and you have to write it. Now, the most I think troublesome things in these days is that we are out of habit of writing. So what I did was that before 15 days were left in the exams, I tried to write things again and again, and whatever I used to read, I tried to write it as fast as I could, because everyone told me that the paper is very lengthy and you have to attempt so much, and that's actually right, because when we start writing, then you have to think and write. These days we are only working on computers. You even have the audio recorders. So these days, even in my when I saw my grandfather or my father giving dictations, I used to be really amused that they are thinking so quickly, dictating, and the person is taking notes. Now we are in this era where you don't have to have somebody to write what you are dictating. You have the recordings, and what I do is I do whenever I have to dictate a synopsis or anything, I just record it and I send it to the typist, and the job is done. So we are actually not in the habit of writing. So that is one thing, that even if you know a lot, you have to also produce it on the paper. So that is important. And in drafting, they give you, so basically they are not looking as if how good grounds you can formulate, or the best question of laws that you can formulate, but they're also looking at the provisions that are there. So when there are certain paragraphs, the SLPs are numbered and then the paragraph numbers are fixed. So if they give you an SLP, they see that you should know what paragraphs are important, what are the regulations, the rules that you're writing which are important, because registry ka kaam defect lagana hota hai, and if you don't write those rules, or you write them wrong, then there are so many defects. So it's important that you write quickly and you write correctly. So that's for drafting. Then you have leading cases. Now, when I gave the exam, there were some 47 judgments, and there are all judgments which we have grown up with. We've been reading them when we did our law. Then, of course, after graduating, then when I did my LLM, that time also, and then later on in the practice, these are the leading judgments which all of us at some point in time, we read them. So when you are actually preparing for this leading cases paper, it is important to at least, if the time is less, because I guess this time there were more than 60 cases, I think 67. So what is important is that you, at least if you don't have much of time, you prepare at least 60% of those thoroughly. You should have read them once, and the rest, if you don't have much of time, then at least you should have read the head notes that are provided, because it's an open book kind of an exam for leading cases, and you get in 2 volumes. You get the judgments and the head notes and the explanations that are there in between the head notes. So that is provided. So even if you haven't read the judgment in full, but if you have read the head notes once, at least you would know this question comes from where, from which judgment, probably because the questions won't be very direct. They won't be giving you the case, the case name and everything, and then they would ask. They would probably ask you the final end result, what was achieved in that case. And if you would have read that case once, then probably you would be able to attempt that quickly. And even if it is like an open book, it's not that easy, because if you haven't read that judgment, then it is very difficult for that from those 2 volumes to find where exactly is that judgment. So that's point number 2. Then there is professional ethics. Of course, when we are talking about ethics, it depends on each individual, but the main focus in ethics is, you have to be ready with your Advocates Act. You should know the basic mannerisms that an advocate should follow, and you should be able to know what is allowed, what is not allowed off to an advocate or to an advocate on record later. So these are, some points that some quick points that I had, and also, when I said that you get 5 chances, then it's something like, even if you appear in one of the papers, then that chance is counted. So the registry normally gives you a date before the exams, and if for any some circumstances which are not in your hand, if you're not able to appear in any of the exams, or there's a problem, then you should indicate that immediately and not take that chance, so that your chance is not counted. So this is very, very important when you are preparing for Aor exams. And I'll tell you one of my very practical experiences. So I was when I was not an AOR, and I was doing my work here, there was one matter which came like, really at the last moment, and it was a very, very urgent matter, and it was told to me that if you file it by tomorrow, then there are any chances that something can be done or some relief can be taken. Otherwise, it would become infructuous. So infructuous, every one of us know that even if then you file a case, there's no relief that can be given by the court in the circumstances of that particular case. So I tried my level best, and it was probably a holiday and thereafter the next day that I had to file that case. Everything was prepared, everything was done, but just for the filing, I had to really run pillar to post. After taking the signatures from the AOR, then to get the defects removed, to get it numbered, all those things took really, it was an uphill task because the registry doesn't recognize you. Then you have to, every time you have to carry an authority letter or an authorization from the AOR that you can cure those defects. You have to take your clerk along with you. And there are so many things that becomes really difficult. So from that point on, I decided that, you can be an arguing counsel. There are so many people say that they love to argue, and it's not important that you be an AOR and you are drafting or you are filing. Fair enough. It depends on you. We as advocates, I think we have the largest possible choices available with us. You can be an AOR, yet be only an arguing counsel. But the effect of becoming an AOR is huge in Supreme Court. So whatever you want to do, but if you become an AOR, then the things get easy for you. Even you don't want to draft, fine, but the registry recognizes you. Your name is there in the cause list. So a lot of things become very, very easy when you are an AOR. I'm a 2003 batch advocate, and I appeared in 2013 because so initially I had this notion that it's really not important. If you're not an AOR, you can still survive in the Supreme Court. There's nothing very, very great about it. But from my own experiences, I'm telling you, and I also got to know that it is important to be one. And that is why if you want to be practicing in Supreme Court, try and give this exam. It's not difficult if you are practicing here. So that's my advice to all of you. And many a times now, even like in the VC mode of hearing that is going on, even that recognizes the AORs, because when you send appearances, when you even send your adjournment letters, these things might appear as very, very small things, but I'm just telling you the practical aspect of it. When you have to request someone that, please, I'm not able to attend the court, kindly circulate this letter for me. Of course, your office can do everything, but then when you are an AOR, you are deciding all these things. And when you are not, then you have to tell someone else to do it for you. The person may or may not available at that particular point in time. So it's important that you are, that it's not. I mean, just on the lighter side, some people say that the AORs are not doing much of the advocate's work. They are acting like. It's like a clerical job, drafting what you're doing. So it's, I don't believe that. It's absolutely, not true. I can say that, because when you are doing your matters, then if you're drafting that, if you have time, even till today, though I'm not doing much of the drafting, you don't get time as in when, the years increase in your practice, but at least, we try and formulate the question of laws, we try and write the synopsis. Because in Supreme Court, what is most important is your synopsis and your question of laws that you are framing. So you have got if you are able to do that, then your 95% of the work is done. And whenever you're going to appear in that matter, it will always be easy. You will be prepared. You would have read the brief. It would take less time. So that's also one thing. So according to me, these are certain very basic tips that you should keep in mind if you want to become an AOR. There are other things also when you are appearing in these exams. One is that I have told you about the leading cases. Earlier, we also had accountancy. Just before, when I appeared, a batch before it was removed, and it was good because if you're not from maths background, it was really tough for you. So out of these 4 papers, according to me, practice and procedure is one paper where you can score well. Then drafting also. Leading cases, it depends. Of course, professional ethics according to me, it's the least scoring. But practice and procedure is like, the 2-mark questions that you have. If if you've been there in the court, in the Supreme Court, then that's the place where that's the paper where you can score the maximum of marks. And you have to, out of those 4 papers, you have to have 50% more marks in all the papers, and the aggregate should be above 60%. So when the results are out, and if you fail in one, then there are regulations dealing with that you can either opt for, if you've passed in all 4, but your aggregate is not 60, then you can choose which subjects you want to appear again and all those. But I really don't want to take on that. I really wish that all of you who would appear in Aor exams, you pass with flying colors. And there are so many judges at present who were in Aor, who were practicing in the Supreme Court. And when you appear before them, it's a delight at times, because if you tell them some of your problems, something, they would immediately catch that. So even in Delhi High Court, there are many judges who were in Aors, and now there are judges. So it's a matter of extreme proud for the Aors that there are judges who are also there. And so that's, I think, what I have. It's not possible to give you a detailed lecture on each of those 4 papers. Maybe my co-speaker, Mr. Namit, he's a very, very brilliant AOR. I think he cleared his AOR with flying colors. He's a very intelligent young advocate on record, and maybe he would be touching on few subjects more in detail. But as far as the introduction part is concerned, that's from my side. Thank you very much for inviting me, and all the best, everyone. Thank you. Thank you, Vanchika.
Thank you very much, ma'am. It was indeed very insightful to get it from someone who has experienced all those things. And that was why we have you here amongst us. Now I would introduce you to Mr. Namit Saxena, who is an advocate on record at the Supreme Court of India, enrolled with the Bar Council of Rajasthan. After graduating in law from Dr. Ram Manohar Lohia National Law University, Lucknow in 2013, Mr. Namit was selected to work as a law clerk cum research associate at the Supreme Court of India and was attached with Honorable Mr. Justice Kurian Joseph for a period of 1 year. After finishing his clerkship at the Supreme Court, he decided to join the bar and was offered a position at the chambers of the Solicitor General for India, Mr. Ranjit Kumar, where he worked for a brief period before starting his own practice. He has a dedicated taste for academic writing and has published various articles with various newspapers, including The Pioneer, The Deccan Herald, The Times of India, Mail Today, amongst many. He has also published research papers with journals of high repute, including Economic and Political Weekly, SEC Online, and magazines including The Practical Lawyer, Lex Witness, amongst various others. He has revised and co-authored 5 legal classics, including Code of Criminal Procedures, Ratan Lal and Dheeraj Lal, and Civil Procedure Code Mullah. He has also assisted Justice Jasti Chalameshwar and Justice D.S. Naidu in revising the MP Jain's constitutional law. We are delighted to have you amongst us today, sir. Now I would request you to take over the platform.
Hi, thank you so much, Vanchika. Archana ji, all my colleagues, especially Rohit Pandey ji, who's a leader of our bar. Thank you for the wonderful words, and thank you for the wonderful words, Archana ji, as well. Like you said, the years 2008 and 2013 are also very important to me as they are important to you, because in 2008 is when I joined my law school, and in 2013 is when I graduated. So that way, we have that similarity with us. So Archana ji has already, highlighted the importance of AOR and what are the basics of, the exam, the eligibility criteria, everything. So I'll just brush up as to, what the Advocates Act says, what the Supreme Court rules say, how are the papers conducted, and what you can, do to, start preparing for the exam. Now, the Advocates Act 1961 does not classify as an advocate on record. It classifies the advocates only into two classifications: advocates and senior advocates. Now, when the Supreme Court was established, because this Advocates Act interestingly came in 1961, the Supreme Court, came prior to it. Then we had two other legislative enactments of 1926 and 1931. So when the Supreme Court rules were framed for the first time, they incorporated that that there'll be a separate category for this court who will be advocate on records. Now, an advocate on record is not an employment. An advocate on record is not, in a sense, which gives you anything as such, apart from being a different criteria or a different classification for people, for advocates who are practicing in the Supreme Court, so that they can lodge their wakalatnamas. The basic difference is this: if you're an advocate, you can lodge your wakalatnama across the country, subject to, of course, there are certain requirements of having a local lawyer or also. But for the Supreme Court to lodge a wakalatnama in your name, you have to be an advocate on record. So there's an added advantage that for an AOR that you can lodge wakalatnama in your name in the Supreme Court. Or senior advocates also don't lodge wakalatnamas as per the Bar Council rules, but only advocate on records can lodge wakalatnamas in the Supreme Court is one. Second, the eligibility criteria, as Archana ji also highlighted, you have to have an experience of 5 years, that is 4+1, 4 years experience anywhere across the country. But 1 year mandatorily, you have to train yourself under an AOR who has had 10 years of work ex as an AOR. So that you get yourself you groomed up in a sense of the basic nitty-gritties of practice as such. So what you have to do is after you complete your 4 years at bar, or in fact prior to it as well. I'm so sorry, I couldn't switch on my camera because I'm traveling. I had to urgently travel somewhere, so I'm keeping my camera off. I hope it's okay with everybody, especially Ashina ji. I'm so sorry. Now continuing with the what I was saying. Now what happens is as an AOR you have to have 4+1 1 year training. Now when you have to start your 1 year training, you have to get a commencement certificate from an AOR who has had 10 years of work ex. Now, that commencement certificate, along with some registration fee, you have to deposit it in the registry, the concerned branch of the registry of the Supreme Court. And after 1 year, you have to give a completion certificate from the same AOR that that so and so gentleman, so and so has completed 1 year training under me, and I found him to be good or whatever. There is a fixed format for it. Now, once that happens, that part of 1 year compulsory training for you is over. And once your 5 years are complete, you will be eligible to write the exam. Now, as per the Supreme Court rules, the AOR exam is to be conducted twice a year, but in practice, it is conducted only once a year. That is primarily in June. Because of Corona, there has been some shift. Last year, it was conducted in December. But we are hopeful again, now that Corona has subsided, it will again be conducted in June this year. So, exams are conducted in June. There are 4 papers, as Archana ji highlighted: drafting, practice procedure, leading cases, and professional ethics. Now, practice procedure primarily contains questions on, and these are all 100 marks paper. You have to get 50 to pass individual exams, and aggregate you have to get 60%. That is 240 marks out of 400 to clear the paper. Now, for practice and procedure, that is, there's a set of Supreme Court rules 2013. Then you have the Advocates Act. Then you have various legislative enactments under which appeals go to the Supreme Court, and under which Supreme Court has some appellate jurisdiction in a sense. And then we have Article 136 also as well, which has the jurisdiction of a special leave, where you don't have a right to appeal as such, but you're seeking that please grant me leave to appeal so that I may be heard accordingly. Now, for preparing, there are books available although, but I suggest that you go through the practice and procedure, the Supreme Court rules very carefully. Now, many of these rules are in day-to-day practice. Whenever you'll do your training under, the AOR, you'll see many of these uh, rules which are there in Supreme Court rules 2013. You'll use them. because you'll file applications under them. You'll see what are the powers of the registrar, which application goes to the registrar, which application goes to the chamber judge, what is the scope and width of power of a vacation judge, when do the vacations summer vacations or winter vacations, or now the minimum number of days the Supreme Court has to sit in a year. So all these, the powers of the Chief Justice, how references are made from from two judge to three judge to five judge to seven judge. So all this you learn in the for the paper of practice and procedure. Now the Supreme Court rules primarily contain them, but the Supreme Court rules are at the end of the day are rules, so they supplant whatever is written in the Constitution or whatever is written in the legislative enactments which are made by the Parliament, giving appellate jurisdiction to the Supreme Court. Now, a few of them have been repealed lately, but there are few cases pending. For example, we had TADA. So appeals, under TADA used to go directly from the special court to the Supreme Court. Now we don't have TADA anymore, but there are still few appeals which are pending here there. Now, for the paper of drafting, again, these are all 100 marks paper. You have to in 3 hours, and these are all 3 hours paper. So in 3 hours, you have to write, you have to answer 4 questions. Generally, they ask 4 questions of 25 marks each, where you may have to draft preliminaries such as counter affidavits or rejoinders. You may be asked to draft a complete SLP. You may be asked to give a synopsis or a list of dates of a particular case. So what you have to remember is that your synopsis, because this is what my senior told me, as I was an associate to Mr. Ranjit Kumar, as Vanshik also pointed out. So he told me that if a judge will never go to your page number 2, he'll never go to your page number 5. That means that your page number 1 has to be written in a manner that attracts the attention of the judge, and which the judge feels that there is some substantial question of law involved for me to interfere with whatever the lower court has decided. Now, then in the drafting paper, they can also ask you to draft civil appeals, criminal appeals, and especially suits under Article 131. Now, 131 is a special, in a sense, a special provision where suits can be filed in the Supreme Court directly when there are disputes between state governments and state governments, or state government and central government on one hand, or state governments on the other hand, or between central government and the state government. Now these are suits. Now lately, what has been happening is states have started challenging constitutionality of provisions under provision under Article 131 as well, which is a suit. But I don't know. Although I don't think it is in a suit you can do it, but nevertheless it is being done right now. Now in 131, not all disputes. No, the expressions used as state governments. So you can't the central government can't go against another instrumentality of state, because that is not state under Article 12 as such. That is a state government which which can be used, which can be put to defend itself under Article 131. Now, when you draft under a suit, the cause title which you make will be XYZ as plaintiff versus ABC as defendant. So you have to keep in mind that basic things, that if it is a petitioner versus respondent, a plaintiff versus defendant, and in drafting they can also ask you to draft certain interlocutory applications. So, for example, in the Supreme Court in civil matters you file IAs, in criminal matters you file criminal miscellaneous petitions, something which we in short form we call it as CRLMP. So you have to keep these small things in mind, which which you learn in your mandatory training for 1 year. That is the legislative intent behind it. Now then we have leading cases. When I also wrote the exam in 2019, there were around 44 leading cases. Now they've increased it to 64, I think, and and they've added case one in the Bharati in it now. So for leading cases, you'll be given an open. It's an open book exam. You will be given head notes from SCR, that is Supreme Court reports, for the paper in a paper bound in a hardbound volume. So you can read. You'll have to read those judgments from. You can read them from SCC or anywhere. But when you keep your a set for your final revision, you should keep it in in the SCR head notes form. That will help you in in the exam, because it's a 3-year exam. You'll also have to keep in mind who was the dissenting judge, what is the ratio laid down, And most particularly and most importantly, you'll have to see the follow up of that particular case. For example, in the case of Bangalore water supply is there in the list, which defined or redefined in the sense the definition of industry for the purposes of Industrial Disputes Act 1947. And this is subsequently referred to a larger bench, then again referred to a larger bench in 2005 and then 2017. So you'll have to see a follow up of that as well. Similarly, when you see the judgment of Selby, also, please remember that whenever you read a judgment for the purposes of this exam, for leading cases exam, you have to see, in what context did this come to the Supreme Court? Is it a civil appeal? Is it a writ petition? Is it an SLP? Or, then converted into a civil appeal? So you'll have to see this as well. For example, Selby versus State of Karnataka. So we used to have one lady who was, infamous by the name Dr. Nako. She used to be in Bangalore, and this is when Selvi was in 2008. So you have to see that period from 2001 onwards, when bombing happened in US. So then there was a series of bomb blasts which are occurring globally, and then India also saw a lot of terrorist attacks in that period. So what this Dr. Narko used to do was she used to inject something which was known as a truth serum. So the investigating agencies then started, injecting, and you have to also remember the ruling establishment changed in 2004 and they amended the UAPA in 2008. So in this context, you have to see that, she used to inject truth serum to accused, and then the investigating agencies, particularly NIA, National Investigating Agency, it used to extract confessions from these accused, and they were put to court as part of judicial confessions that that he has confessed the crime, so that the accused he's put to a disadvantage during trial because he himself said something during the lie detector test after truth serum was injected to him. Now it went to the Supreme Court. Supreme Court said nothing doing. This is incorrect. You can't do this because of the provision of 20 clause, Article 20, clause 3 of the Constitution, which defines, in a sense, defines or implies self-incrimination. So when you read Selvi, you have to go back to Article 20, Clause 3. You have to go back to this 1964 judgment, which goes by the name Kartikalu Ogad. And then, you gradually come to, and there's this uh, legislative enactment of 1920, which goes by the name Identification of Prisoners Act 1920. You have to see that. And after 2008, you have to also see the follow-up of Selvi. Now, follow-up of Selvi, you'll see like in Puttaswamy, the right to privacy case, you'll see that privacy was broadly divided into mental and physical privacy. So you'll have to also see this judgment, if it comes to you in the question paper, from the perspective of right to privacy as well. And then after, we have this Ritesh Sinha's judgment, which deals with voice sample. So whether it is voluntary or does it come under the category of testimonial compulsion? So you'll have to see, so all these judgments, whenever you read them, you'll have to see them from the perspective of, what is the history behind it, and what is the follow up of these judgments. Similarly, you'll have a judgment of by the name TMA Pi now, or Indra Sawhney for that matter. So whenever you have to broadly categorize the reservation. So like in our constitution, Article 14, 15, and 16, they constitute the reservation code as such. Now you'll have to see as to how did this petition, came to a 9-judge bench in Indra Sawhney? What was the law, previously? So you'll have to go back to Champagiran Dorai Rajan, and you'll have to, in fact, go back to the government of India. That there's this communal bill, if you guys know, by the British government. So you'll have to, because everything has a very interesting history. That will be a very good learning exercise for you as well. So that way, you'll have to prepare yourself for leading cases. Then for professional ethics, again, as Archana ma'am pointed out, you'll have to again go through the Advocates Act, and you'll have to also supplant yourself, your arguments, your submissions, and form of your answers with the Bar Council of India rules, which contain your duty to the client, your duty to the opposite counsel, duty to the court, etc. Then you'll have to also see judgments on, advocates lien on the brief, and then there are, many judgments which deal with what should be the conduct of an advocate. So that is how you basically equip yourself for the exam. Now coming to the practical part of it, see, like last year because of Corona, it happened in December. Otherwise, it happens in June. So June in Delhi, and these exams are conducted in the Supreme Court premises under the supervision of Supreme Court registry officials. So, you have to remember that this is generally 10 to 1, 10 a.m. to 1 p.m. So this is peak summer we are talking about. So you'll have to equip yourself with, that you keep yourself, fit and healthy for the purpose of exam as well. And, you have to do time management because these are four consecutive papers, one after the other. So you by the time fourth paper you have to answer, you get exhausted because you have been reading a lot, etc. Because as Archana ma'am also pointed out, we are no more in habit of writing. So that is something which you'll have to because for example, what we do in the Supreme Court now is we just copy paste SLPs, and we don't draft that certificate by hand anymore, etc. Now for the drafting paper, a certificate by the AOR can be asked. A certificate, you may have to draft a certificate for a review petition. You may have to draft something for a curative petition, because there also a certificate is required, saying that what is how is order 48 applicable, or Rupa Ashoka law applicable. So you'll have to equip yourself in that manner. And it involves a lot of reading. So, speak, and also remember, for example, advocates' right to lien is asked. Everybody will write, Contracts Act Section 71 and RD Saxena's judgment. So you have to equip yourself with something which not everybody is going to write. And that is, I think, in my view, that is what the intention of conducting this exam was. That that you equip yourself to to be in a manner that you do something, you get in, you give something extra from others. So that way, is with that perspective, that you have to not only clear the exam, you have to also prepare yourself for something better, because there's a preparation after all. And that is how I think you should go about it. I think that's it. We'll be, in fact, if Archana ji permits, we'll be very happy to answer a few questions if you guys have any questions for us. Vanchika.
Thank you,
Yeah,
sir.
of course. I think that can be really good. If there are any questions, we'll be more than happy to answer. Just one more thing which I forget, and I was thinking if Namit ji would deal with it, it will be good. But since both of us have forgotten, it just clicked to me. There are also lectures that happen, and the senior advocates give lectures just before these exams. Those are very, very important, because they are there, either they are the paper setters or they are there in the Supreme Court for so long, and they give you some very short lectures, some quick points. And nowadays those lectures are also there recorded. This time it happened, I think, so those are all recorded. So those are very important. If you just hear them, your half of the preparation is done, and then you just have to only read the other things, in detail. That is important. And one more thing, just to add to what Namitji said, when he was talking about leading cases, that's right, that you have to also see the later developments in law that happened. Like in this year's paper, they had a question about the appointment, the eligibility qualifications to the post of district judges, as set out in Article 233 of the Constitution of India. Now, that we know is the famous judgment of Satyanarayan. But recently in 2020, there was this judgment of Dheeraj More, where it was again elaborated upon. I was fortunate to be a part of that judgment. But then that's how, starting from Satyanarayan, you have Dheeraj More. So you should be knowing that lineage. Otherwise, if you are only writing about the oldest case, and then the checker, the senior advocates who are checking these papers, they are all here, and they know from reading your answer sheets whether you have just crammed up what's written in the book, or you know actually what's going on day to day in the courts. So your GK also should be good. You should be knowing the latest pronouncements, how the law is taking shape. That is very important. That's it from my side. Any questions? We'll be happy to answer. Thank you.
As Archana just pointed out, lectures are very important. So there's this there's this trick which we guys use. So, and this is not something, this is something in form of an unwritten rule. So whosoever takes that lecture, maybe the paper setter, and maybe the checker of the exam. This is not written anywhere. This is undeclared, this thing. So when you prepare yourself, for example, if Mr. Siddharth Luthra is taking a lecture on a particular subject, You can also consider looking into, past 1 year's, his judgments, any landmark judgments which he has argued. So there may be questions from it as well. So in follow-ups of leading cases also. So that way, these are small tricks which you guys, you can use for your preparation. And that may, give an advantage to you. Vanshika, if there are any questions, we'll both be very happy to answer.
Thank you very much, sir. Thank you very much, ma'am. If we have any questions, I'll request the attendees to drop the questions in the chat box, and then you can answer the questions. I would also request you to address the speaker while asking the question so that there is no confusion. Thank you.
Someone was raising a hand, I think.
Yeah, so there's Sushil Kumar Shukla and Akhil Bagri. Maybe, I don't know if, I think you'll have to unmute them, or the chat option, that's also not there. It's disabled.
We're just looking into it, ma'am. We're actually enabling them
Yeah.
to enter their questions in the chat box. It was disabled to avoid any distractions.
Right.
In the meantime, I would thank you, thank both Mr. Namit and Ms. Archana. It was a wonderful session, actually. Although I do not intend to practice in the Supreme Court, I have no intentions of going into litigation as such. But I think after listening to you both, I am tempted to become a litigating, to become a practicing lawyer instead of joining any law firm. It was a very interesting session. Thank you very much.
In fact, Vanchika, it's not necessary that you can't practice anywhere. That is why I said Aor is just an additional qualification. You can practice in the Supreme Court with this, but you can, keep on practicing in all trial courts, all high courts, all tribunals along with this as well. So it is an additional advantage only.
Absolutely.
Yeah, right. But she said she doesn't want to become a litigation lawyer.
That's a very risky position, ma'am. Actually, to be honest, I'm a little scared.
Let's do a session on litigation lawyers versus corporate lawyers. That's also one thing. I know most of the youngsters I see nowadays, they want to opt for corporate lawyership. I don't know. But being in litigation is one of the best things that I can tell you, because
I understand
for
that.
some time I was also in a law firm, and I'm not saying that's, but I don't know. To me, it wasn't that interesting. In litigation, I'm telling you, at the end of the day, even in the matters where you don't get any fees, but you get one good order, that's sufficient. That raises your morale so high. So
you don't worry about the fees at that time. You're like, chalo chodo, now I've got the order, that's all right.
No, it's initially, yeah, there are, I know you have to really struggle hard. So when I say that, in 2013 I gave my Aor exam, means after 10 years I thought that yes, now if I give exam and if I clear, maybe I'll be able to do something in Supreme Court. That was after 10 years. So it definitely takes time, but once you are there, doing maybe 5 years or so, then I think things move, they start moving. But
so
you have to be
patient
patient in litigation, that's for sure. Thank you very much for having us over. It was indeed a very nice, chat today. I thoroughly enjoyed. Thank you, organizers. Thank you, Rohit Pandeyji. Thank you, Vanshika. Thank you, Namit.
Thank you very much, ma'am. Thank you.
Thank you.
Thank you. All the best.
Thank you, sir. Thank you very much.
So we leave Vanshika now?
Yes, ma'am, you can leave now.
Thank you.
Thank you.